Hello. This presentation is about how Bill S-215 will attempt to begin a shift towards a safer society for Aboriginal women in Canada moving forward. Bill S-215 is an act that would amend the criminal code surrounding the sentencing for violent offences against Aboriginal women. The bill was proposed by Senator Lillian Dick from Saskatchewan. Overall, the goal of the bill is to fill a void that exists in the legal protection of Aboriginal women in the criminal code currently. This proposed change would fall under the category of positivistic law and Indigenous law. If the amendment passes, it would have astounding impacts moving forward for Indigenous women across the country for years to come. Before moving forward, it is important to properly situate violence against Aboriginal women in the proper historical context. Cases of unsolved murders and violent offences against Aboriginal women have been happening for decades. Cases are not limited to Saskatchewan and can be found across the country. Recently, it has come to light that violence against Aboriginal women has gone overlooked by both the government and Canadians alike. This oversight has led to the stories finally garnering the national media attention that it deserves. The headlines across the nation have led to calls for action to come from the people. This has placed the onus for action and justice on both the federal and provincial governments across the country. Within Canada, there are several other groups that have been afforded protected status. This means that offences against them incur aggravating circumstances when sentencing occurs. The other groups that are currently protected and afforded this status are transgendered individuals, service dogs, taxi drivers, and public transit operators. If the bill is passed, Aboriginals will be added to this list of currently protected groups within Canada. Continuing on, it is time to look at legal issues that may arise surrounding the passing of Bill S-215. As with any bill that attempts to pass through Parliament, there are some issues that may arise, especially in the case of a bill that looks to amend parts of the justice system as well as the criminal code. One of the greatest issues is the fact that changing the criminal code may prove to be more difficult than estimated. Just because the bill is passed through Parliament does not mean that its validity is certain to be upheld by the judicial system. It could face roadblocks, setbacks, and challenges from all levels of the judiciary system, including the Supreme Court of Canada, thus causing extreme legal issues moving forward surrounding this bill. Another issue that may arise may be that the designation of protected group is not granted to Aboriginals, thereby causing little or no change to occur in reality, even though the bill has been passed. Just because this bill passes does not guarantee that the status of protected group will be given and upheld for Aboriginals moving forward within Saskatchewan. Bill S-215 would have an astounding impact on Canada if it were to be passed by the federal government. Since the bill would amend the criminal code, this would have a significant impact on the judicial system. New precedents would need to be established surrounding the sentencing of violent offenders of Aboriginal women. Bill S-215's passing may also inspire calls from society for further legislation to be passed within individual provinces at the provincial government level. The bill could serve as a precedent for provinces attempting to pass similar legislation in the future, thus ensuring further protection for Aboriginal women moving forward in Canada.